Thank you. Thank you for kind introduction again. As Professor Ogilvy introduced, my main area is electronic bills of lading, and it's actually very recent that I came to think about this private international law aspect of electronic bill of lading. So maybe I have to start with the apology that I'm not really an expert on private international law. But I'm just here to give a lecture. So I will not try to waste your time. I will keep it very short. We have time. We need that time for discussion, and we need time for lunch. So I will keep it very, very short. That's a good news, right?
Now.
Just a few more minutes. We appreciate it. And I have to thank Professor Purvis because thanks to his presentation, I can save like 5-10 minutes, first 5-10 minutes before the presentation. So my presentation, I think, will be less than 20 minutes. So we talked about this function equivalence as a kind of a principle that applies to the laws and the modern laws that start to think about electronic commerce in the legal framework in not only in national legislation but also international model law. But this function equivalation is something that we can also think about both in practice and law. I mean, we were trying to use the electronic transmission. We're trying to just achieve the function and consequence of what's going to happen. Based if we use the paper form of document. So, for example, in practice, by secure transmission of information, designation of a holder according to the third-party system, the contract and agreed rules like the Bolero system, we were able to achieve this functional equivalence. In law, I mean, of course, in contract, they decided to transfer the rights, but the rights are only transferred as contracted and effected under the given governing law. So Bolero system, for example, is governed by English law. And before 2023 Electronic Trade Document Act, we had to rely on novation and attornment. But now we have this new law, ETDA 2022, that gives the legal effect to electronic bills of lading. Now, the English law, the ETDA 2023 will be the governing law of the Bolero system. Development in practice, I think it's just the background information. I think one interesting thing is the 2022 electronic bill of lading standard, because I think I mentioned last time when we talked about this autonomous ship, when it comes to development technology and recognition of law, it's always about the interoperability of the technology. So what BIMCO has been doing since 2022 with this standard, they were trying to make this a standard so that different platforms can exchange and transmit the electronic bill of lading information so that anyone can exchange and use electronic bill of lading. I just want to mention here the blockchain, the importance of blockchain system. We talked about several times, but I mean, it is the blockchain system that actually played a major role in transforming the landscape of when it comes to using and giving legal change for the electronic bill of lading. So actually, for the last 5 years, there were 12 electronic, I think 10 electronic bill of lading system, and 9 of them were blockchain system. And I actually started counting, but every 3-4 months that there was a new blockchain system registered. So these are the 12 electronic systems that are currently approved by PNI Club International Group. So I just want to mention the importance of blockchain system, how important role this blockchain system has made in electronic bill of lading. So development in law, we already talked about it, term rules and early adopters. Before Unho model law and electronic transfer records were adopted, the US, Australia, Korea, Germany did have and currently also have the legal regime legislation for giving the legal effect to electronic bill of lading. And since this adoption of model law, 10 states that have adopted MLATR, including Singapore, UK, France, as introduced yesterday by Professor Pejovic. So just looking at this trend, we have an increasing number of substantive laws giving legal effect to election bill of lading. That, that's the implication is, of course, that will affect, the legislators of other countries. Okay, we have to hurry up in making legislation or revising our legislation to give effect to election bill of lading. Another thing is, well always the legal development affects the practice too. So probably the parties or potential parties have more assurance that maybe we'll be able to use election bill of lading with a legal recognition backed by the increasing number of substantive laws. So that's a kind of a trend now. But that also makes me think that, okay, what if the substantive law that gives legal effect to election bill of lading is not applicable to election bill of lading? So this is the question of applicable law. So I think there was a mention yesterday, like in reality, 80% of the governing law of bill of lading is English law. But well, we still have to think about this 20%, that where the English law is not chosen as a governing law. And even though, it is, English law is chosen, theoretically, not every case, this English law or whatever the governing law that is chosen by the parties may not be applicable to the bill of lading related disputes. So in order to address these kind of questions, I also have to go through the very basic questions that I have as a kind of beginner of the private international law and choice of law. How is the governing law determined for bills of lading? Is always the law chosen by the parties to the contract of carriage? What law should be applicable to election bill of lading considering the latest development? And what law can be applicable? Some exceptional cases also where the bill of lading, the governing law of the bill of lading may not be applicable. So when the law governing the contract of carriage does not coincide with that on a bill of lading, maybe it's very exceptional cases, but while the contract of carriage has a governing law, while the bill of lading might have a different law, like a state beast law. And in such a case, it depends on the relationship of the parties involved in the dispute. So, between the shipper and carrier, of course, the governing law of the contract of carriage will be applicable, whereas between the relation between the carrier and holder, because it has the conclusive evidence, so the governing law of the bill of lading that is included in the bill of lading will be applicable. The second exceptional case we can think about is when parties fail to choose the governing law or the governing law does not exist on bill of lading. Again, it's maybe very exceptional and maybe theoretically, but we can think about the situation where parties fail to explicitly or even impliedly designate the governing law on the bill for the bill of lading. So in such a case, of course, it can be the law of the law where the bill of lading was issued or the law of the destination. But what's important is, and also as many private international law legal regime has, the doctrine of a closest connection will apply. So in most cases, I think because it can be related to, for example, the act of performance. So the carriers, the characteristic performance is related to the carrier's performance. So it may be related to the place where the bill of lading was issued. And that was actually the case in the past in Korea, for example, when were following the old version of the private international law. And the Supreme Court was ruling that it's always the law where the bill of lading was issued in this kind of case when there's no governing law in the bill of lading. But currently we have this similar system, so the doctrine of closest connection will apply. So we will have to look into what is the objective, the closest connection is. And what are the objective factors that we can look into depending on cases and to decide what's the governing law for the bill of lading. When the dispute involves the matters outside the contract relationship, so this is some related to the point that I want to make today. So basically, please let me know if I'm wrong, but the governing law of the bill of lading regulates the contractual relationship between the parties, between the carrier and the holder of the bill of lading. So when it comes to the non-contractual relationship, for example, when it involves a tort claim or when it involves a property claim, then not necessarily the governing law of the bill of lading will regulate such a relationship. So for example, a tort claim for damages arising from the loss or damages to the goods is to be determined by the law between the governing law of the contract between the parties. So, well, this is because the Korean law as well as the Japanese law amended to allow this tort claim applicable law to be decided by the governing law of the contract between the parties. So if they're already in the contractual relationship, we follow the governing law chosen by the parties. So, but the more problem is when it comes to the property claims or when it relates to the proprietary effects, So in that case, the law of the place where the bill of lading or the relevant goods are located will be the law of the governing law. There are like a number of occasions, but I think what's related to the propriety effect or property-related cases are the two in the middle on the table. So, for example, issues on the proprietary effect, negotiability of the bill of lading when the case is related to the proprietary issue between the claim based on bill of lading and claim based on the goods themselves, or the case related to the goods in transit and the goods are disposed in transit, and when it involves issues like related to pledge or endorsement. So in that case, well, because we don't have the private international law or choice of law rule, particularly for the use of a bill of lading, for example. So we have many debates, and some are coming from the precedents, and the major scholarly thoughts are divided into two. One is law of the location of the bill of lading. The other is law of the location of the goods, or sometimes destination law. And also another occasion is related to the property-related claims, such as claims about the requirements or effects of the transfer of the bill of lading, or whether bill of lading can be transferred or not. And that, in such a case, the law of the location of the bill of lading is likely to be the law applicable to the bill of lading to that such a dispute. So in principle, a property changes of movable property are governed by the law of the location where the property is situated. But for negotiable documents, the traditional majority view supports the law of the location of negotiable documents, whereas a recent prevailing view supports, both in Korea and Japan, are the law of the location of the object. But what's related to the development of electronic bill of lading and blockchain bill of lading is actually when the applicable law will be the law of the location of the bill of lading, and if the place where the instrument is located is important, like in the previous slide, and how is the place determined in the case of electronic bill of lading system? So to figure that out, we need to first need to see how each system works. For the central registry, because due to its registry based and it's registered members only. So because it's a closed system, central registry has been not really working seamlessly. Unless parties who are registered as members to the system. And basically, it relies on the third intermediary who's administering or managing the transfer of rights between the parties. So in that case, the place where the bill of lading record is located will be we need to consider the location of the central registry or the third intermediary who's administering the system. And that is likely to be the place where the system manager is located. In the case of the distributed ledger, it's more complicated because the record is theoretically is everywhere. Every time the right is transferred to another person, that the same record is recorded and it's distributed every party involved. So it's difficult to say where exactly the record exists. And of course, when it comes to transferring the rights or the record, and who has the right of control of the record, it's based on the token transfer. But again, the record itself is, when it comes to location of the record, it's mysterious. We don't really know where it is. It's difficult to identify. And another difficulty is coming from the the lack of or absence of this third party. We don't depending on what kind of system we're talking about, what kind of a technology in blockchain system. For example, if it's a permissionless or it's a public, then there's really no one we rely on. So it's like in the case of central registry, unlike the central registry, we cannot really identify who is or where the system manager is located. So this makes it more difficult to determine the place of bill of lading record. There has been some developments. First of all, in the UK, Law Commission started a project called the Digital Assets and Electronic Trade Documents in Private International Law. And I think a preliminary consultation is in progress. I think last February, there was a call for evidence, providing questionnaires to the people, stakeholders, and they are expected to give the answer to those questionnaires. And I think that they already received the answers, but they haven't really published the results yet. So I'm looking forward to looking into those records. But in the process of initiating this project, they and also when they formulated this Electronic Trade Document Act 2023, there was a mention about the private international when it comes to electronic trade documents. So, for example, there are private international law difficulties associated with the electronic trade documents, in particular, the inherent difficulties in determining the geographical location of the documents. So they also acknowledge that there is a difficulty in determining the location of the documents. It also further says that many of these issues arise in relation to digital assets more broadly, so it would not be productive to address it. So the reason is because the legal formulating the law for a digital asset has been in progress, so they decided to wait for development at the side of the digital asset law. So that's why the private intentional law was not dealt with in this Electronic Trade Document Act. And this report was also mentioning the interesting the rule that the right of the holder of the negotiable instrument to which this is of course the traditional rule for the paper-based bill of lading, but this is the it's both determined by the law of the governing the instrument and by the law of the place where the instrument was situated. Switzerland, I think that this shows the most developed version that is applicable to the blockchain bill of lading. So there was actually the amendment or the new legislation for the Federal Act on the adaptation of federal law to developments in distributed ledger technology, which was enacted in 2020, and that allows a BL to be issued in the form of a blockchain-based token. So they are equipped with a substantive law that's directly addressing this blockchain technology record. And what's more important is that there was amendment with the private international law, which became effective since February 1st, 2021. And on Article 106 and Article 145A, it says that this is a new part, and they added this equivalent form so that it also applies to not only the general electronic bill of lading, but also blockchain bill of lading too. And whether a claim is represented by an instrument in paper or equivalent form and transferred by means of such instrument is determined, and they give this priority. First, it should be determined by the law designated therein. So it should be the law designated by the blockchain system, for example. And if no law is designated in such an instrument, then the law of the state in which the issuer has its seat. Failing such, its habitual residence applies. And this is just applies to only the physical when the physical instrument like paper bill of lading was issued. Article 106, which says that the rights in rem to both the instrument and the goods are governed by the law applicable to the instrument as movable property. So when the instrument is still remains in physical form, that the law remains with the this law applicable to the instrument as a movable property. So, and we go to this provision related to the movable property, the location of the instrument at the time. So we follow the law of the location of the instrument at the time of the event where the acquisition of or loss is derived. And for the goods in transit, it will be determined by the law of the destination, because the goods in transit it's difficult to identify exactly where it is. The federal report on, so this was the report when they prepare for this amendment, and it clearly clarifies that the lex certe cite principle has no application to the instrument recorded on a distributed ledger because its status is difficult to be envisioned. So I'm talking about like difficulties and what has been the discussion when it comes to the choice of law rule for the blockchain bill of lading. So I guess considering the stage of my research, which is very early, there's no conclusion. There are a lot of questions that remained. One kind of question that I have is, so because we've looked at there are a variety of technologies even within the blockchain. For example, there's a public blockchain, and even if there is a private or the administrator there to manage the record, but there might be, depending on the design of the system, there might be single or multiple administrators managing the system. And we can talk about, even though there is only one administrator, the administrator can operate the system from different places in electronic world. So there might be more than one place where the administrator is habitually resident. So considering all these varieties of technologies, one question that comes to my mind is, should we prepare for different choice of law rules depending on the technologies? Another kind of question, or maybe this is related to, the kind of one destination I want to touch upon as a result of doing further research on this, is that despite their negotiability and connection to the physical property, if electronic or blockchain-based records are not attached to the place where the record is located, and electronic bills of lading are meant to be used or transferred to or from anyone across the border, shouldn't all other jurisdictions seek the same choice of law rule? For example, as in the case of the Swiss law, the law designated in the instrument, in order to achieve a higher level of certainty in private international. So then the next question I might have is seeking a uniform law for the choice of law applicable to electronic or blockchain bills of lading that may be extended to non-contractual claims. Is it really necessary? And if so, if it's really possible to achieve such a uniform law? That's kind of questions that I'm going to work on. And I hope to, if there's any outcome, I hope to share the result with everyone here. Thank you very much for listening.